Okay, so that was some of the prosecution's opening statement, in the Melanie Eam case. And what she was saying is you're going to hear about the multiple stab wounds, photographs, witnesses. And at the end of the day, it is going to be very clear that Miss Eam murdered James Barry. We are going to prove that to you. But is this such an open and shut case? Is it so simple? Well, let's talk a little bit more about it with my very special guest today. Joining us back here on Law and Crime is criminal defense attorney Randy Zelin. Randy, great to see you.
Good morning.
So this case, not so easy, not so open and shut. It's a little strange, isn't it?
Yes. It is always fascinating to me how quickly prosecutors lose sight of what their ultimate goal is. A prosecutor's role and a prosecutor's job is to do justice, not simply to get a conviction, not to get and go for the gold. What am I really trying to say? Well, when you look at a case like this, you look at the age of the victim, the age of the defendant, you look at the nature of the death, the stabbing, the multiple stabbings. What jumps out at me as a former prosecutor and as a defense attorney? Is this a murder case? Was this intentional? Or did something happen? Was there a fight? Was there some event? Where am I going? Heat of passion. Was the murder not really a murder? Was it a manslaughter? And what is the difference? Well, when you act in a moment of snapping, when you act in a moment of passion, when you act in the moment of the heat of passion, that's not a murder. That's manslaughter. And in this case, it doesn't take a rocket scientist to figure out pretty quickly, even by the number of stabbings. Oftentimes, when you look at multiple stabbing, is that someone who snapped and freaked out as opposed to one stab, one boom to the heart, which is much more typical and much more commonly associated with that intent to kill you. So right away, I say to myself, what are you doing? This is not a real estate transaction where I'm going to start high, you're going to come in low. This is a murder case, so you go for what you believe that you can prove. And if you believe that all you can prove is manslaughter, then that's what you try the case on. It might not be as sexy, it might not be as fun, it might not grab the attention of the headlines, but that's not your job.
And that's what makes this case very unique, because what the prosecution was saying, kind of what Randy was explaining, was they're saying she was a scorned woman after he broke up with her, and maybe this was a heat of passion kind of incident. Well, let's see what the defense is going to argue. We played you some of the prosecution's opening statement. Let's see the defense's. So if Melanie Eam didn't do the stabbing and common sense will tell you who did, then who are we talking about? Well, we are going to learn that the defense is going to be pointing the finger at James Barry's mother's boyfriend, Guy Hand, that he is the actual killer. Randy, that is a very risky defense, to point the finger at another individual, but we've seen it work at other times.
That's what I would refer to as, come on. As a defense attorney, when you get up to do an opening statement, you have a couple of options, but they're always driven by what you're trying to do. You don't just simply throw it up against the wall and see if it sticks, unless that's your strategy. There is nothing wrong with getting up in an opening statement and saying, ladies and gentlemen, you remember what the judge told you. We don't have to prove anything. My client is presumed innocent. And you look back at your client and point to your client, or you put your hands on your client's shoulder and say, my client is presumed innocent. And you promised us that's how you would look at my client. You don't have to start crafting a defense. And why, as you just said, why box yourself into a corner where now you're basically begging the jury to say, come on, show me. Show me that somebody else did it. Show me a motive. You don't have to prove motive, but common sense. Show me a motive. Show me what happened here. Who called 911? She's covered in blood. Were her actions and her behavior consistent with being a witness to what's more horrifying than watching someone else die, let alone your boyfriend? Yeah. So when you look at all of the surrounding circumstances, what does common sense dictate? I can bet you the common sense don't dictate that Guy's hand was the hand responsible for this.
I like that. That was a nice touch, and that was a big point what the prosecution was saying. If she was just a witness to this murder, why didn't she call 911? Well, let's learn a little bit more about the actual event itself. Let's play some of the testimony of Jeffrey Garzabagowski. This is the victim's friend who will explain the moments of the stabbing. Take a look. Okay, that clip cut off, but he goes 90 seconds later, the light left from his eyes. He basically saw his friend pass away. Now, Randy, we're talking about common sense, as the defense says. Common sense will tell you who actually did this, and they're pointing the finger at Guy Hand, who is James Barry's mother's boyfriend at the time. You hear him frantically trying to get help, and that seems to be a chaotic situation. Again, we don't know anything about the relationship that would suggest that there was a conflict, that he was in conflict with his mother's boyfriend, and would ultimately lead to this stabbing. I didn't see anything clear about that.
Because there was nothing. One of the odd things about a trial is that trials are both intuitive and completely counterintuitive. What do I mean by that? You have a bunch of people coming in who are going to decide what happened on a particular day, place, and time. The jury. A judge will look to the jurors and say, ladies and gentlemen, please don't bring anything into this courtroom other than your common sense and your life experiences. But almost in the same breath, that same judge will say that the burden of proof is solely on a prosecutor, solely on the government, solely on the prosecution. The defendant is presumed innocent. The problem is common sense and the way we act in our everyday lives. That's completely counterintuitive. If I were to steal your iPhone right now when you got up and left, and you looked at me and said, Randy, do you know what happened to my iPhone? And I said, Jesse, I don't have to answer you. What would you think?
Right.
Or if I remained silent, what would you think? He took my phone. That's common sense. So right off the bat, common sense is all screwed up in a courtroom. Now you say to the jurors, you don't have to prove anything. Nobody's to prove motive, yet that's common sense. Why would Guy Hand have done this?
So what they keep pointing to is the fact that he had a skill set with knives. You know, he was a butcher. He knew how to use a knife. He was pretty good at that. And also, if you take the dynamics of a relationship where it's the boyfriend of your mother, couldn't the jury say, I could see how there may be conflict, even if nothing happened in a prior occasion. Maybe there's something that leads me to believe there's some doubt here.
I go back to what I said earlier. Come on.
Okay, let's talk more about this, though. So the youth of the victim and the defendant, how does that play for a jury when they look at these two individuals here? I mean, she was 20 years old at the time of the arrest. He was 21 years old. How does a jury look at that?
Well, again, if we now let common sense back in, we think back to being 20 and 21 and putting aside all of the scientific analyses of whether or not your cerebral cortex and your brain is fully formed. You do really stupid things. You get angry, you get emotional, you get passionate. So common sense would dictate if something bad happened, and I'm not minimizing a death, it's probably because somebody snapped.
That's interesting. I mean, this is a case, I get what the prosecution is saying here about a woman who's scorned. We've covered a lot of these kinds of cases, and we're going to talk more about it when we get back, because when we get back, we'll talk more about the actual investigation. This is the Melanie Eam case. We'll be back right after this. Okay, so they're investigating the crime scene. There's blood everywhere. We know that Jeffrey, who was James Barry's friend, was there talking about the blood on his hands. We're talking about now Guy Hand. I'm back here with criminal defense attorney Randy Zelin. Randy, we talked about how it seems maybe improbable that Guy Hand was the one who committed this crime, but the defense really wanted to harp on one important point. They said that Mr. Hand moved the knife to the kitchen. In fact, the defense attorney here said, and he sees blood everywhere, and he picks up the bloody knife, and he takes it into the kitchen to wash it off, to clean it off. He made that statement in his opening remarks. That is suspicious. Why would someone do that if they had nothing to do with the crime?
I've never stabbed someone, or I've never been accused of stabbing someone if I didn't do it, so I can't tell you how I would react under similar circumstances. Everyone reacts differently. But I would suggest to you that if I am someone who just stabbed someone, I probably wouldn't simply clean the knife off and then leave it in a place where it's going to be easily discovered. I'd probably get rid of it. So, yeah, Is it something for the defense to work with? Absolutely. Do you hang your entire case and the life of a young woman on it? I would respectfully submit to you, without more, probably not.
Right. Okay. Well, let's learn a little bit more of the discovery of the knife and the crime scene itself. And I have to tell you, you're going to get a really vivid description of what that crime scene looked like. So let's play some testimony right now from Sergeant Aaron Silver from the Palm Beach County Sheriff's Office, and he will describe the crime scene. Okay, you're learning more about the graphic nature of the crime scene, but we have to talk about one of the biggest aspects of this case, the fact that Melanie Eam provided an alleged confession to police, but the defense had a really tough time about trying to keep that out. Randy, so they couldn't keep that out. Can you explain a little bit about how that works, the dynamics of how they were trying to keep this confession out, but they ultimately couldn't? The jury had to hear this.
Sure. Let's put aside whatever we watch on Law and Crime shows. In order to have a confession be admissible in evidence, if I, again, using the cell phone example, if I confess to taking your cell phone, there are two components to that in order for the confession to come in to be used against me. Number one, I have to be in custody, and that's critically important in this case. The second piece of it is that I have to be asked questions by law enforcement, the answers to which would get me into trouble. So there are two components. There is custody and there is interrogation. And in this particular case, as we will find, the prosecution will successfully argue, wait a minute, she was not in custody. What does in custody mean? Would a reasonable person believe that he or she was free to leave? So if you are interrogating me right now, you're law enforcement and I'm a suspect. If I can leave through that door, if there's nothing stopping me, if you never say to me, Randy, by the way, you ain't going anywhere. If I, as a reasonable person, would believe that, you know what, this conversation's over, Jesse, I'm leaving, I am not in custody. And if I'm not in custody, then I do not have to be advised of my right to remain silent, what we call the Miranda warnings. Because in this case, again, their argument was she was never read her Miranda warnings. She was never told she had a right to keep her mouth shut. And the prosecution successfully argued she didn't need to be Mirandized because she was not in custody. She was free to leave. The confession took place at her aunt's home in Maryland. She wasn't in a police station. She wasn't in handcuffs. She was told that she could leave, apparently. There was nothing there that would have led her to believe that she could not get up at any time and say, I'm out of here, this conversation is over.
Why would she confess then? You know, I mean, that's the strange part. If she wanted to say, I was able to get out of there and someone else did this, committed this crime, how's the defense going to say that someone else committed this crime, but she confessed?
Blame it on, well, I don't know. What's that song, Blame It on the Whatever?
Yeah. Blame it on the rain?
Again, blame it on the rain. No, that's the part that's confounding. If you know the confession's coming in, I mean, unless you're setting this up for an appeal,
right?
Where, okay, I'm going to lose the trial, but when we go upstairs to the appellate division or the appellate department or the appeals court, if we get the confession thrown out, now we're cool because we've blamed it on someone else, and the next trial, there's not going to be a confession coming in. Short of that, I ain't got a clue.
Because a lot of people would look at that and be like, maybe they should have gone with a different kind of defense here. Like you said, Randy, maybe say she did it, but, you know, some
exactly. If I did it.
Yeah, if I did it. All right, so we're going to take a quick break. When we come back, a lot more to discuss in the Melanie Eam case, and we will let you know the verdict a little bit later on today. Okay, so you're learning a little bit more about this really horrific crime scene. I'm back here with criminal defense attorney Randy Zelin. Randy, in your experience, stabbings of this nature, really violent, does that tell you or does it indicate to you who might have done this? Is this a personal kind of attack as opposed to a shooting or some other kind of way? Or does it tell you, in other words, would it be Melanie Eam who was broken up with or somebody else?
Well, certainly there's no science to it. But when you think about it again, it's all about common sense. When you think about killing someone, as bizarre as that might sound, different ways of killing someone suggest different levels of a relationship, different levels of emotion. Stabbing someone is a very visceral kind of, you're in close proximity, you're not far away. It's a much more personal encounter, and it's a much more personal interaction. And to stab someone, if you think about it, unless you've got unusually long arms, you're going to be really close to the person.
Right.
So just the nature of the encounter suggests something. It suggests emotion and anger and just thinking clearly going out the window. The number of stabbings, and that's something about this case that I found fascinating. If you said to an expert, one stab wound versus multiple stab wounds, that expert is likely to tell you one stab wound, that's intentional. That's a murder. I meant to kill you. Multiple stab wounds, I lost my mind, I snapped, and I'm just hacking away. And again, that may seem counterintuitive.
Right.
The average person may think, well, if I really want to kill someone, I'm going to stab them a lot. No, if you stab someone a lot, you probably lost your mind. That's heat of passion. That is manslaughter, not murder.
We're going to talk about that right next. First, I want to play a little bit more from Neil Zelinsky, the crime scene investigator, and I warn you that this is we're going to see very close-up shots of certain pieces of evidence in this case, and you're going to see the family of James Barry getting very emotional in the courtroom. But when Randy and I get back, we're going to talk more about second-degree murder versus manslaughter. But let's play some testimony right now.
Yeah.
Okay, you see as the evidence is being displayed for the jury, family members of the victim were getting very emotional, and rightfully so. This is a horrific, horrific case. Let's talk a little bit more about one of the technical aspects here with Randy Zelin. So, Randy, she was charged with second-degree murder. I'm confused. Why not charge her at least with first-degree murder? If that doesn't work, tell the jury you can go to second-degree murder, and if you can't get second-degree murder, go to manslaughter. Why not start with first?
Well, again, going back to something that I said earlier, somewhat tongue-in-cheek, which is this is not a real estate transaction. We don't start high as a prosecutor. Defense comes in low and then figure out if we can agree on a purchase price. No, a prosecutor is bound to do justice, so you should charge what you can prove. But to your point, in Florida, murder, manslaughter, what are the definitions? First-degree murder in Florida is premeditation. I thought about killing you, I intended to kill you, and I killed you. Even if I formed that thought in my mind a second before, that was my intention.
And there's nothing from the facts of this case that would indicate that? I mean, she went over to his place, and, I mean, they're claiming she went over and killed him.
Well, does common sense tell you that she went over there to kill him, or did she go over there because she was upset, and in the course of being upset, she killed him?
Now,
there's a difference.
And that means that premeditation, if she got upset, she couldn't form that premeditation right at that moment and kill him. That's not how it works.
Well, that's not how it works, but let's go to the in-between, because Florida is interesting. Florida, you have first-degree premeditation. Second-degree is what's called depraved indifference, a depraved mind, which is I have zero regard for human life. The difference between depraved indifference and manslaughter in Florida is that with depraved indifference, I intended to kill you. It may not have been premeditated, but my purpose, my goal, my intention was to kill you, as opposed to manslaughter, which is I didn't intend to kill you. I just lost my mind.
Right. These distinctions are fascinating, and I'll tell you, this becomes a big issue later on. We'll talk more about why in the Melanie Eam case. But when we come back, we're going to talk about the Daniel Villegas verdict. Now, we haven't told you what it is yet, but we are going to let you know. So stay tuned here on Law and Crime. Okay, so you're learning a little bit more about the crime scene itself. I'm back here with Randy Zelin. Now, Randy, you and I are going to talk more about the difference between second-degree murder and manslaughter, but not quite yet, because we have to hit a break soon. So let's just talk more about a different aspect, the evidence that the prosecution's building up. They're saying, hey, look at all this blood that was in her car, but couldn't that support the idea that, yes, she ran away, she wasn't the killer?
Well, think about what you just said. Why would she run away if she wasn't the killer? And it really teaches us a very valuable lesson, which is oftentimes it's not what we do, it's what we do afterwards.
That's a good point, and we're going to have to talk about that because that's something that the defense or the prosecution really harps on. We'll take a quick break. Randy and I will be right back. Okay, so we know that blood was found in this key location, but let's talk with Randy Zelin about what we have here in terms of second-degree murder versus manslaughter. So, Randy, the way that the story goes, if you want to say the prosecution, okay, we believe that she committed this crime. We believe she was a scorned lover. How do we differentiate the facts of this, the stabbing, between second-degree murder and manslaughter if she is the one who actually stabbed her ex-boyfriend?
What it comes down to, and this is very, very nuanced, what it really comes down to is, does the evidence support an intent for her to kill him? If the evidence supports that she intended to kill him, then that leans towards second-degree murder. If the evidence points to she did not intend to kill him, and let's put aside intending to go there to kill him, because
right.
if she went there with the intention of killing him, that's first-degree murder. So just toss that one out. So what we're talking about is the difference between second-degree murder and manslaughter. The difference technically is, was there an intention to kill the person? If I lost my mind, I snap, and I did not intend to kill anybody, but someone dies, in that moment of passion, in the heat of the moment, that's manslaughter.
Right.
But if at any time, hey, listen, I intended to kill you, then that's where you get into that depraved mind. In other words, it's almost as if I didn't care if I killed you or not, and you could die, and you died.
But if you are the only person who knows what really happened, how does a jury sit there and be like, oh, we know what went on in the defendant's mind?
Well, that's where common sense kicks in, and that's where an analysis of the evidence kicks in. And that is where the definition of reasonable doubt kicks in. And what is the definition of reasonable doubt? It is any time you have to make a really, really important decision in your life, whether to have open heart surgery, whether to get married. If you have enough information to make those decisions, you don't have a reasonable doubt. Conversely, if you need a second opinion from another doctor, or you want to wait and see a few months before you pop the question, you need more information. Therefore, you have a reasonable doubt. So here you look at the evidence, and does the evidence support that she intended to kill him at any moment in time, premeditated or not? If it's, you don't need any more information, yeah, you know what? She intended to kill him, it's second-degree murder. If you need more information, he walks unless you have charged him with manslaughter.
That's interesting. That's really interesting. And this is something the jury is ultimately going to have to consider. We'll play you the verdict a little bit later. But they have some more evidence to consider themselves. And this is why I want to play more of LaShawn Perkins, a forensic specialist, who's going to talk, actually, you know what, we're not going to play LaShawn. We're going to play Cynthia Steinhaus, who is a nurse, a neighbor of the victim, who provides some really crucial testimony that you may have missed in this case. Take a look. Okay, we are learning the prosecution's case right now in the Melanie Eam trial. I'm back here with Randy Zelin. Now, Randy, one of the things we talked about earlier, but I want to elaborate on is, if you're the prosecution, what kind of jury do you want in this case where you have a young victim and a young defendant?
Well, I think first and foremost, you're going to want a juror who's going to follow directions, someone who's not going to deviate from what I will call the rules, whether that person may think it's right or not right, or fair or not fair. I want someone who likes to play follow the leader. I want someone who's not going to have any independent thought process and kind of stray from the judge's instructions, and who will follow the evidence and will almost have blinders on. Because, as you just said, young person, this kind of fact pattern, and if I make a decision as a prosecutor that I'm going for it all, I'm not going to go for that middle-of-the-road verdict, that manslaughter, and give the jury something to kind of split the baby with, so to speak, then I want someone who's going to be, that's it, I'm going in this direction, and I don't care if there's another way to go. I am following the directions, and that's it.
And if you're the defense, do you want a jury that, hey, maybe has some experience in homes where parents got remarried, because you have a situation here where the defense is pointing the finger at the mother's new boyfriend and that he's the killer. What kind of jury do you want if you're the defense?
Well, certainly whether you actually get someone on the jury who is either a second spouse or a child where there was a second marriage, we all know that common sense tells us that it's a very difficult dynamic. So whether you have someone who's actually experienced it because they've lived it or is at least familiar with it, then certainly as the defendant, yeah, I want somebody who could say, I can understand tension, I could understand problems, I can understand difficulties when you have a boyfriend or a girlfriend or a second spouse in the picture, right, in the bedroom with mom.
But either way, these kinds of cases are never easy for a jury to consider, especially when we were talking about before the difference between second-degree murder and manslaughter. It gets technical, even for lawyers.
Well, that's where the prosecution, quite frankly, they're the ones responsible for making it more difficult. Charge this case based upon what the evidence supports, which is this girl probably did not intend to go there to kill him, did not intend to kill him, but she snapped. And if that's what the evidence supports, it's manslaughter. That's what you charge. That's what you ultimately say, do you want to plead guilty or do you want to go to trial? But that's what you go to trial on.
But if you're also fighting for justice for the family, because manslaughter doesn't hold as much of a penalty as a murder charge, and maybe we'll talk more about that because we have to hit a quick break, and we'll talk more about that when we get back. But there's a lot more to discuss in Melanie Eam, so stay tuned here on Law and Crime. All right, so let's pull out of that clip and talk a little bit more here with Randy Zelin. Randy, one of the big things that you and I were just talking about was that Melanie Eam wanted a lawyer. That was one of the very first things that she said when she was questioned by police. Now, there was a discussion about whether or not she wasn't arrested yet, and there was a discussion about whether or not she was in custody when she gave this confession. But the fact that she asked for a lawyer, what do you make of that?
Well, don't take my word for it. The Sixth Amendment to the Constitution of the United States says that you have a right to counsel. And she invoked her right to counsel. So I find fascinating in watching with you and listening with you and your viewers and having had an opportunity to read the judge's decision, because there was a motion made by the defense to throw the confession out. The defense said, Judge, this confession should not come in. This confession should not come in because, first of all, she was not read her Miranda warnings, and she should have been, and she should have been told that she had a right to remain silent, and she had a right to have an attorney present, and that didn't happen. And we all know what the judge did with that. The judge said, well, wait a minute, you weren't in custody. You weren't in custody, so it's fine. You didn't have to.
Well, let's talk about that, the idea of her not being in custody. If she couldn't, if her car was impounded and she couldn't leave, her house was under constant surveillance.
Why couldn't she leave, though?
But is that a way that she's a 20-year-old girl? Isn't it what she believes?
Look, just because her car was impounded doesn't mean she wasn't free to leave. It may have been more difficult for her to get someplace, but she could have walked out and walked to the street. So she was free to leave. The fact that she's under surveillance, just because somebody's watching you, that doesn't mean that your freedom of movement is restricted such that you feel that you are in custody. So, again, it's nuanced. But what I point to, if this case ever goes upstairs to a higher court, if I'm the higher court, I'm like, wait a minute, time out. I'm not really interested in the notion of custody and interrogation. What about the fact that she invoked her right to counsel and that was completely ignored? Yeah. That interview should have been shut down. That confession is gone. What does this trial look like without her confession?
That's a good point. I mean, that's a really good point. And that's the why did the police deny her the right to have an attorney? I don't understand that.
Because the whole case rises and falls on a confession. In any case, if you can get a confession, over, goodbye, good night, see ya.
But they know better. If they're mimicking her, not mimic, if they're teasing her about the idea of getting an attorney, what's your attorney going to say, or your attorney's going to help you? That seems like textbook no-nos.
Well, I'll give you a couple of responses. Number one, don't assume that law enforcement understands that. And number two, How many cases go to trial? 3%, 2%, 4%? So if I'm law enforcement, I'm saying to myself, this case is never going to trial. And oh, by the way, with a confession, there's no way in hell that it's going to trial. So I'm not really interested. And plus, the relationship between a detective and a prosecutor on a state level as opposed to a federal level is, detective, I make an arrest, I close a file, I move on to the next one.
Right.
I'm not married to this case like I am an agent, and that close relationship between an agent and an assistant United States attorney where you live and die with that case.
That's a good
so
point.
I don't really care.
Yeah, well, now we're having to talk about it and see what actually happened. Okay, we talked a little bit about Guy Hand. This is, again, the victim's mother's boyfriend, the person that the defense says is the actual killer. Well, he took the stand. Let's see how he did. Okay, so this is an interesting role for the prosecution, and I'm back here with criminal defense attorney Randy Zelin. We always talk about defense, putting on their client on the stand, the risk of that. But the prosecution puts this witness on the stand who's almost like has to come off as credible in their own right? Because this is the person that the defense is saying is the actual killer. It kind of reverses itself in a way, right?
Well, yes, and if the most important thing that it does, it now prevents the defense from arguing what we like to call the empty chair defense, which is someone else did it. And boy, wouldn't it have been nice to have had them here in this courtroom? Well, now you do. So it's a poker game. It's like, see you? Okay, I call, I raise you. Here he is. Knock yourself out. Go have a party with him.
Why does this work sometimes and not other times? In other words, I've seen cases before where you have a defendant point the finger at the boyfriend of the victim or somebody that knew the victim and say, that's the person who actually committed this crime, and it doesn't work. Then you have other cases, and I'll give you an example. Alexander Bradley in the Aaron Hernandez case. The jury said, you know what, it seems maybe there's more to this story. So how does it work? How does it really work when you point the finger at somebody else if you really don't have a ton of evidence to support that?
Well, here's the thing. First of all, you have to have something. And here, in this case, again, common sense, knee-jerk reaction, that defense strategy of blaming it on the boyfriend is silly, and it really defies common sense. And as we know, it also completely goes against the evidence. By putting him on the stand, as I said, the prosecution is inviting the defense. Here's your defense. Knock yourself out. I dare you. And, of course, what's always most important is you have to be reasonably confident that the person that you're calling as a prosecution witness actually didn't do it.
Right. Yeah, that's a great point. That's a very intuitive. So the idea that he's a butcher, handled knives, cleaned the knife off after the attack, that in and of itself may not be enough.
It's silly. I mean, come on. First of all, if he's a butcher, then you start arguing, well, that he certainly knows what to do with the knife, and he's not going to sit there and start hacking somebody up. The fact that he cleaned the knife, you would just simply say, listen, ladies and gentlemen, who knows how we react in a moment? Do you think he got out of bed expecting to see his girlfriend's son dying of stab wounds?
No.
Lord only knows what possessed him to do what he did, but that doesn't change the fact that he is not responsible. This was not done at his hand.
And
so to speak.
So to speak. And there's no evidence that we have seen that they had a tumultuous relationship where there was conflict, that they fought in the past. I'm talking, of course, about the victim and his mother's boyfriend. We haven't seen anything like that, which may have helped the defense's story. But there's a lot more to discuss. So when we come back, we'll further our discussion in the Melanie Eam trial. Okay, so we're listening to the man himself, Guy Hand, explain what happened when James Barry was fighting for his life after suffering numerous stab wounds. I'm back here with Randy Zelin. Randy, when you look at a witness, you're in a different position than a regular juror, but you are in a different position. What are you looking for telltale signs of something doesn't add up or something, there's a hint of dishonesty, especially if you're working for the defense for Melanie Eam? What are you looking at in his testimony?
Well, certainly there are cues that you look for. The most obvious is whether or not his testimony seems to be rehearsed, whether or not he's really not answering the questions. Then you look for those little telltale signs. Who is he looking at? How is he behaving? Is he looking down? Is he looking around? Is he looking the prosecutor in the eye? Is he sweating? Does he seem nervous more than simply anybody being in the witness box? But with all of that, it really still comes down to, what does the evidence show us? What does the evidence point to? Is there any evidence on this planet to suggest that the prosecution is actually questioning the killer? And if there's no evidence there, man, you are on a suicide run for your client. That was an insanely, insanely stupid thing to do in your opening statement, because jurors, you make a jury a promise, you damn well better keep that promise. Otherwise, just like in real life, you ain't got any credibility.
Let's play a little bit more of Guy Hand. And when we come back, Randy and I are going to talk about how he ultimately did on the stand. Take a look.
What do we hear? Jam screaming, help, help.
All right, and I think we can't play that clip just yet, but we're going to hit a break. When we come back, we're going to play more of the Melanie Eam confession tape that you may not have seen. So stay tuned here on Law and Crime. That's the police interview. That's the Melanie Eam alleged confession tape. A lot of things were on there. A lot of emotions were running high. Let's get the reaction right now from Randy Zelin. What do you think?
I'll take a check, please. My God, I don't know what it must have felt like for defense counsel to be sitting there next to his client, watching and listening as the jurors heard his client confess in no uncertain terms. When you just got up there not too long before and said, ladies and gentlemen, Guy Hand did it. I mean, you just sit there, you just look for a place to run and hide. But again, what I find most compelling is the fact that it's pretty clear that at some point she actually doesn't ask. She doesn't simply ask, because asking an argument could be made. Listen, if the defendant asks for a lawyer and she's not in custody, and I don't have to read her Miranda warnings, then I don't have to tell her. But once she says, I want to speak to a lawyer, to me, if I am an appellate judge, I'm going, time out.
Yep.
She asked for a lawyer, and that interrogation, that conversation, those questions, those answers continued by law enforcement? No.
I'm surprised it did continue, and I'm surprised it was let in. I mean, again, the discussion about whether or not she was under arrest, whether or not she was in custody. But again, you made a really good point. We see it in TV shows all the time. Somebody says lawyer, they're not allowed to continue questioning. How did that happen here?
Well, I don't know. And certainly when you read the judge's decision, and the judge's decision to say the confession comes in, the judge spent an extraordinary amount of time analyzing Florida law on the question of custody. And there's a case called Ramirez that talks about when a defendant is entitled to have the Miranda warnings read to him or her, and it goes into a lengthy discussion about custody. But amazingly, on the issue of the right to counsel, the judge basically swept it under the rug and basically said, it's not a big deal.
That's shocking. That's shocking. Now, but then again, at the end of the day, she just did confess to doing this and said she didn't mean to, and explained how, James Barry hurt her by breaking up with her. But that's not the end of the conversation. Because let's get back to Guy Hand. This is the defense pointing the finger at this man and saying, this is the one who committed this crime. I don't care about that confession tape. Well, let's learn from Detective John Oliver from the Palm Beach County Sheriff's Office if Mr. Hand was ever a suspect. Let's see. Guy Hand was never a suspect. Nothing alarmed investigators to him. Seems really confusing case. Seems a little messy. Now, Randy, I know our time together is coming to an end, so I just want your final thoughts about this case, because it does seem a little messy, doesn't it?
It's more than messy. What this case teaches us, and what I hope teaches your viewers, it is why defense lawyers do what it is that we do. It's not simply about, oh my God, how can you defend people when you know that they did something wrong? No. Oftentimes, our job as defense lawyers is to make sure that the system works properly, that everyone does their job, because clearly here, law enforcement didn't do its job properly. They had no business continuing to question that woman once she asked for a lawyer. So it's our job as defense lawyers to keep law enforcement honest. The fact that the prosecution chose to prosecute a case on second-degree murder when clearly it's a manslaughter case, it's our job to push back and say no. So all of you viewers should understand that our job as defense lawyers, there could be a billion people that we defend that did it, but there's that one person who didn't. And it's our job to make sure that that one person who didn't do it doesn't get screwed over by a system that doesn't want to play fair.
That's very well said, Randy, and I'm happy you made that point, because despite what the ultimate verdict is in Melanie Eam, that's the larger issue for any case that we cover. So, Randy, thank you so much for coming in, as always, and you have to come back again soon.
Thank you for having me.
All right, so here's what we're going to do, ladies and gentlemen. We are going to continue talking about Melanie Eam, and when we come back, we will just go a little bit more into the testimony, and a little bit later on in the program, we will eventually tell you the decision of the jury. And let me tell you something, it might not be what you expect. So stay tuned here on Law and Crime. We are covering a lot. We'll be right back right after this.